Hello, friends. Good morning. It's morning here in Virginia, and good afternoon. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm, immigration law firm here in Virginia near Washington, D.C. So today I will briefly talk to you about the what we call usual suspects, the issues that we see most in filing for adjustment of status, for naturalization, and for asylum cases. So the issues we see, the specific issues that we call usual suspects here in our firm, that are we frequently see in the asylum applications, citizenship, the forms in themselves, in answering the questions in the forms. Um, as you know, when you file for, and then, after this, explaining this, after touching upon this topic, I will answer any questions, preferably as much questions as possible related to this topic, because it's a very hot topic and it's a very big issue in many of the applications that we see from the clients who come to us after they fill out their own forms or file, or some other firm may have handled their case. And then I will try to answer any other questions that you may have. So what is the usual suspects? What do we call usual suspects? Usual suspects are the questions in the forms that we see frequently answered wrong by the clients. Some of them may be because they're afraid to disclose the information. Some of it may be because they make a mistake in answering that question. So one of those usual suspects is the question about unauthorized employment in the past. So, for example, if you apply for adjustment of status in the United States, you are filing for a green card, for example, based on your marriage with a U.S. citizen, and there is a question: have you ever worked without authorization in the United States? I didn't remember the number of the question or which page it is, or the form I-485, but we see frequently clients resisting to answer this information truthfully. They may have worked somewhere without authorization, but they don't want to disclose it because of the fear that it will disqualify for them from the adjustment of status. In most of the scenarios, especially in the cases of adjustment of status through marriage with U.S. citizen, the fact that you worked without authorization would not disqualify you. And same applies for asylum, obviously. So if you worked without authorization, that will not disqualify you from asylum eligibility. But hiding that information will disqualify you. And in the marriage-based case, it will be material misrepresentation, which will make you inadmissible. In the context of asylum case, this will significantly damage your credibility. What it means is that if the immigration office finds out, the USCIS asylum office finds out that you worked without authorization, but you did not disclose that, then, or you didn't tell the truth, then that will significantly damage your credibility. And same applies in immigration court. So if you're in immigration court and trying to prove your asylum case, answering questions, if it's determined that you worked without authorization, that's not going to cause your asylum to be denied in any way. But the fact that you failed to disclose it, or you lied, that will cause your asylum case being denied. So because of the credibility, because the judge will find that you're lying now, so why should they believe your entire asylum story? And the reason why it doesn't disqualify you from permanent residency based on marriage with a U.S. citizen, or in some employment-based cases in adjustment of status, as long as that violation was within the past 6 months before you applied for adjustment of status, or in the context of asylum, is because working without authorization is not a criminal violation, is not an immoral act. It's not on its own basis for disqualifying you from your form of relief. Employment without authorization is violation of your status. And as we know, for the purposes of adjustment of status through marriage, or adjustment of status through employment-based adjustment of status, where the violation of status occurred within the last 6 months, And for the purpose of asylum, the violation of status does not matter whatsoever. It doesn't matter. It's not going to cause the denial. It doesn't bar you from that belief. So again, when you are answering this question about the employment authorization in those forms, please be careful. Please consider it carefully and be truthful about it, and do not hide that information. Because one of the most frequent questions I get when I tell the clients that, look, we need to disclose this, the question comes from the client is, oh, how will they know? Are they gonna, dig my information with IRS or with contact my employers and so on? Well, the answer is, first of all, they're not going to disclose what they do, and the government doesn't disclose all of their enforcement, tools that they utilize. But aside from that, yes, of course, it's a federal government. I mean, IRS is part of the federal government. Then the states governments cooperate. I mean, there are many ways. One, the United States federal government can find out that you are employed, but the other simpler way that they can find out is just pure logic. So somebody enters the United States as a visitor, and they spend 6 months, or sometimes 8 months, 9 months, or 11 months before they apply for asylum, to make sure that they apply within 1 year. And then before they can get their EAD, employment authorization document, they wait another 6 months. And it's a family, or it's just a young person who entered the US and applied for asylum. So for about almost a year and a half, this person has lived in the United States, and their asylum case basically describes how they've been suffering in their country of persecution and so on. And they're saying in their application, no, I have not worked until I received my EAD. I mean, think about it logically. Does that make sense? So, the immigration officer and the judge will be immediately triggered to assume that you're lying. You're lying now in front of them in your asylum interview and in your asylum hearing. So don't do it. They're not stupid. They will understand it doesn't make sense that a family of 4 comes into the United States and they're saying that, oh, we never worked with authorization for a year and a half because we're such an honest people that we were waiting, or morally good people waiting. No, actually, in the context of, for example, cancellation of removal, where the judge looks into history or how this applicant has been a hard worker, breadwinner for the family, the bona fides, the positive factors, they do look into that past employment history. And even though it's all assumed that before the cancellation of removal is granted and the applicant becomes a permanent resident, this applicant probably had no status in the United States and never had a work authorization, or if had for a brief amount of time. But the bottom line is, all of that time, it's assumed that they should be working, and it's a positive factor. So working without authorization is not a crime. It's not an immoral act. It's a status violation. So before you start freaking out that, oh, I worked without authorization, it will mess up my case, do talk to the lawyer and consider this carefully, and do disclose one way or another. You have to be truthful about it, but talk to the lawyer and they'll tell you how to do it and how to make sure that you are most secure in the answers and explanations that you provide. The second usual suspect that we see most often is answering the question about criminal history. So, as we all know, if you had a little incident where you may have been detained, for example, you had a reckless driving, or you had a disorderly conduct, or drunk in public, those type of charges, you may have been detained, arrested, cited, charged. But then even if the case is dismissed, that goes into your record. Now, we all know that there is a way to seal your records or to expunge your records. It's called expungement. So your criminal lawyer may have represented you, and then the case was dismissed. It was a mistake. You shouldn't have been charged. And now you ask your criminal lawyer and they expunge your records and they say the records don't exist. You don't have to disclose it. Now, what these criminal lawyers often don't tell you is that you don't have to disclose it to the public, but not to the federal government. I mean, you have to disclose it to the federal government. So that whether your records are expunged or not, the question in the forms asks, have you ever been arrested, right? So if you get arrested and then expunge the records and charge and so on, the fact that you were arrested doesn't get expunged. It happened. It's the truth. You were arrested. So do disclose that to the federal government. So the federal government is asking you in the forms, have you ever been arrested? Whether those charges or arrests have been expunged, the records have been expunged, the answer is yes. And then you go on to describe. Now, regarding expunging records, I also want to tell you that it's sometimes, shooting yourself in the foot, because if you expunge your records, those records become unavailable. There is a way for you to get those records, unseal them, and obtain for you, your own purposes, but it's a hassle. So before you expunge any charge, get a certified copy of all those records and keep it for yourself. Get multiple copies of certified, basically the court clerk stamps it. That's what it means. And then go through the expunging, because I see too many cases where clients come to us and say, yes, I had an incident, but the records have been expunged. Then they work for months and months to try to reopen and get those records, because the court keeps saying that the records have been expunged. That means we don't have those. Anyway, the criminal lawyers can take care of that part. But yeah, so even a minor incident, the forms, they recently changed, meaning several years ago, they changed the forms, the naturalization form and adjustment of status form, to include even citations. So in the past, it was actually specifically excluding traffic citations. It was saying, the question on the form I-485 was, have you ever been charged, convicted, detained, or imprisoned, or cited by any law enforcement anywhere in the world, excluding traffic, in the parentheses, violations. But they changed it, so they don't have it now yet. So if you read the form, it says, have you ever been charged, detained, convicted, blah, 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 or cited. And traffic tickets are citations. Now, what's the story? What you should do to answer this question? Almost in every case, most of the clients had traffic tickets. I mean, I had traffic tickets. A lot of people have traffic tickets. That's only moral. That's, it's probably a bad habit to get traffic tickets, speeding tickets. But the bottom line is, the answer is, mandatory yes, if you had a traffic ticket. And then you put in the description, in the explanation, that I had speeding tickets. Now, you don't have to provide the records, unless it was DUI, it was reckless driving, where you were arrested, or, there was misdemeanor charge, anything other than traffic violation, what they call is administrative violation. So other than that, everything you have to obtain the records, certified disposition records. But the bottom line is, it's better to disclose it rather than not disclose it. When you answer yes or no to these questions, whether you work without authorization, let's say you did some volunteering work, you thought that it was, as long as you didn't get paid, it was not employment without authorization, and then your lawyer tells you that it is, you have to disclose, which is, it is, because even if you don't get paid, that actually makes it worse. That means, your employer was taking advantage of U.S. immigration laws and not paying you just to make it seem like it's not employment. But by doing that work, you're still taking the space of a potential U.S. worker, which is the reason why there are restrictions on employment in any country, is to protect its own workforce. So I get frequently asked, if I work without pay, volunteer for some organization, is that an employment? The answer is, the test is to look into that job to see if this could be done. Let's say if you didn't volunteer and do it free of charge, would that be done by someone who would be employed and get paid in the United States? If the answer is yes, then you worked without authorization, whether you got paid or not. But the bottom line is, if you didn't think that it was employment and you're arguing that no, that probably wasn't, it was one day gig, I went and did this for some event, I thought it was not employment without authorization, you can say no as answer to the question, but the advice is always lean towards disclosing it. So if there is anything that makes you believe that maybe you should have said yes, you can say no or yes. That's not as important as disclosing that fact, the explanation of what made you believe one way or another. So that's regarding employment without authorization and disclosing. Now, regarding criminal charges, convictions, why it is also one of the most important usual suspects, most frequent usual suspects. in our practice, where we see a lot of clients making mistakes in answering those questions. That happens a lot in the context of somebody who in the past filed for asylum, either got asylum and now filing for adjustment of status or citizenship, or in the context of somebody who filed for asylum and then they got married with a U.S. citizen, or one way or another they got through the process of adjustment of status in the United States, through abuse or whatever that might be. So what we see a lot of times, clients, and sometimes actually frequently lawyers making mistakes, is they don't refer back to their previous, to the applicants, to the client's previous application. What I mean is asylum applications. So for example, client files for asylum, and part of the asylum declaration includes the information about being detained briefly at the airport upon returning from foreign trip because of the political opinion, or being detained at a rally. Let's talk about the most classical asylum story. You've been detained at the rally because you protested against the government, you expressed your political opinion. Even if you were not jailed, imprisoned, or charged, and so on, you have been detained, because in your story you're saying how the police, handcuffed you, put you in a bus full of people, and took you to somewhere to the outskirts of the city and let you out, which we see a lot of authoritarian regimes doing that. So that happened in your asylum case. Now you got asylum, you're happy. Year later, you are filing for adjustment of status. And in the question, it asks, have you ever been charged, convicted, or detained by any law enforcement anywhere in the world? Whether it was lawful or unlawful detention, it doesn't say that. It says, have you ever been detained? So the answer is yes. If your asylum story, if your asylum case says that you were detained, as long as that's truthful, and we're assuming that was truth. So if you were detained there, do disclose it here too. And then guess what? Even after citizenship, so you got this now adjustment of status, and then you got green card. With asylum, it's backdated 1 year, so 4 years later you apply for citizenship. Same question. So again, you have to disclose that, yes, I've been detained. This was disclosed in my asylum case. Here's what happened. And the USCIS will have access to your asylum file, and they can look into it. So referring back and comparing all of the previous forms and applications filed is extremely important, because when you file for green card adjustment of status, the immigration service will go back and look at your previous immigration history, your F1, how you applied for a visitor visa, what documents you provided. They even have access to your consulate file, what you told the consular officer, your previous status, your EADs, OPT, all of that is going to be looked into when you apply for a green card. When you apply for citizenship, all of your history, including that green card application, the adjustment of status, is going to be looked into. So they will once more go through. All of this assumes the immigration officer is diligent. Of course, there are immigration officers that are not that diligent, they're overwhelmed, or they're just, signing off and moving on. Some of you may be lucky, even if you have issues, they may not pay attention, but that's not what you should be hoping for. That's very rare. But one of the other issues we see most often is, the applicant has a lawyer representation, they handle their asylum case, and then they're filing the adjustment of status on their own without a lawyer. And then they get caught on this. Or they made a mistake in the adjustment of status, which was overlooked, and now they got the citizenship, and they're thinking, oh, it's a piece of cake, I will do it myself. I'm not trying to sell the services of a lawyer, which is part of what we do. I'm not going to hide it. But the bottom line is, we see a lot of cases. And I've closed the case about a couple of months ago. Thankfully, we won it in immigration court, where my clients were, and I think I had a video about that case, actually. They were from South Korea, and they went through employment-based process and got perm and got green card through EB3 process. And then they got their green cards down the road, and then They got to citizenship stage many years later. I think it was about 12 years later or so. And at the citizenship interview, when they were asked about past employment, they gave false information, wrong information. And then the USCIS went back and looked at all of their previous case, revoked their permanent residency, placed them in removal proceedings. I defended them in immigration court. It was extensive and difficult hearing, but thankfully we won. But they were this close to being deported. It was an entire family. It was children who were now adults who also got their permanent residency through that process. All of their citizenship applications were stopped. The bottom line is, don't do it. Any immigration violations, the Form I-485 asks, have you ever violated your status in the past? Have you ever been refused a visa? There is a question, I believe, in the DS-260 or DS-160 form with the consulate when you go through the National Visa Center and so on. I don't remember exactly if there is that question in the I-485. I believe it's not. But there is a question in the DS forms asking, have you ever been refused a visa? And a lot of times I see that overlooked, where the applicants, who have applied in the past for a visitor visa and so on, were denied or had a visitor visa which was revoked, and now they're going through employment-based or marriage-based case, and in their DS forms, they're saying, no, I've never been refused a visa. So those are the usual suspects: status violations, employment without authorization, being charged, detained, or cited, or convicted, paroled, and so on and so on. Even immigration detention qualifies for detention. So all of that are usual suspects when you or your lawyer or whoever you work with, don't work with anybody but yourself or your lawyer, licensed attorney. So anybody you're working with or filling out these forms, when you go through those questions, stop, take time, pay attention, think about it, talk about this with your lawyer carefully, and do not just quickly answer yes or no. Otherwise, it will come. There is a good chance it will come back and bite you. So I will go into questions. Let's see. There's a question saying, sorry, Ismail, sir, would this broadcast be made available later? This caught me off guard, and I'm in noisy environment, but very much interested in discussion. Yes, it will be available later. There will be, so this link will be permanent, and it will be permanent on our YouTube channel. As you can see, the previous broadcast is there. Fastest green card options available this year. I don't think there is a difference between the years, and I don't think there is such a thing as fastest green card options. I think the question means, and there is no such thing as easiest. I mean, there are green card options that are suitable for you or not. Sometimes, I get asked that question, and that's a legitimate question. People want to know, and during the consultations, somebody consults with me, and then they say, oh, what's the easiest way to get a green card? I say, well, how my answer is going to help you, Let's say the easiest way for you is to get married with a U.S. citizen, but you're married, you have children, you're happily married. So how does this answer help you? Or the easiest way is to win the green card in the lottery. It's not something I can help you with other than applying. You should apply for it. Otherwise, you're never going to win or never going to have a chance to win. So apply for the lottery. But that's not, I guess that's not the right question. I mean, there are fast ways, there are slower ways. I think you should narrow down. And I made a video. I don't think it has been posted yet. It was just made the other day as I was coming back from immigration office in the car. One of my advices is before you consult with an immigration lawyer, to make the most out of your time you spend with an immigration lawyer during your consultation, narrow down the options, the immigration options, using the publicly available information, online search. Go to our website. We have almost every immigration option described in our website. The reason I'm saying this is because you don't want to just ask, how can I come to the US? Well, there are many ways. If we talk about all those ways, the consultation is not going to be enough. You probably need 50 consultations to talk about every possible option. So, but narrow down at least within a category. So, are you planning to invest and open your own business in the US? Then we can talk about those options. There are multiple options. Are you planning to come to the US through your profession, whether you're going to find an employer who's sponsoring you, whether you have, as an outstanding professor, researcher, talented person, national interest waivers, or one. So there are multiple employment ways. Whether there is, your plan, you have relatives and it's family reunification, or this one way or another. So try to narrow down at least to the category, and then we can talk about which one of them is fastest or more likely that could work for you. Okay, next question: how to illegally cross the Mexico-U.S. border? The question actually says how to illegally cross the Mexico-U.S. border. I'm glad this is being asked because in this public forum, because first of all, it's what do you call it? It's an anonymous question because it's posted on my admin. We posted as an anonymous question. So an immigration attorney in the United States, we as licensed attorneys, we're considered officers of immigration court. We're part of the immigration system of the United States, and we're held to the highest standards. So no immigration attorney can, should, or is allowed to teach you or tell you how to do things illegally, like how to lie in your asylum application or in your forms, how to hide information from immigration services. That's not what attorney is here for. We can help you navigate through the trauma because you lied in the past, or help you present information one way or another without lying, but presenting it different or rephrasing. We can help you to bring your case in the best light to, in most advantageous manner for your case to improve your chances, but without lying. So the same way here. It's just questions blatantly asking how to illegally cross the Mexico. Don't do it. There is no mechanism to do it. We're not, and we don't recommend. And there are illegal organizations who do that. Don't get involved. And it's not just because I'm trying to sound like I'm saint here, but in this practice we do hear people getting abused, getting raped, sexually abused, or dying or starving almost near to death while they're trying to illegally cross the border because some organization, some individuals, coyotes or so on, they got money and they promised, a happy arrival in the U.S. and they ended up crossing the desert and drowning in the river and so on. So don't do it. Don't cross illegally. But there are legal ways to come to the United States. Obviously, visas and so on, humanitarian paroles now, for Ukrainians, for Haitians, who else, for Nicaraguans. They start for Cubans. There is a way to bring your relatives. So if you have any relative or friend or anybody from those countries who's considering coming here illegally, tell them not to do it. You can easily fill out the form and bring them here within a matter of weeks. And they will come here legally. They'll board the plane. They'll arrive normally. So don't resort to illegal crossings. And that's often a topic. A lot of conservatives and Republicans say that, well, that's what Trump was trying to do, is to prevent illegal crossing by building a fence. Fence has never stopped. What stopped is creating legal ways for something that you expect to happen illegally anyway. So if you have, extreme poverty and danger right across your fence, and people are fleeing for their lives and freedoms, there's going to be no fence that will stop it. They'll either break this fence or they'll overcome it. They'll jump over it. So fence is a way of showing off that I'm trying to do something to stop illegal immigration. But that didn't. The fact of the matter is that didn't. We all remember, those caravans of immigrants. What happened to those caravans? Do you think that caravans was dispersed? Were there, Mexican or American authorities with batons and face masks going and kicking them out? No, that didn't happen. So most of that caravan ended up here at the time when Trump was Trump administration was in power. So that didn't work. So the way to stop it is not by building fences. All right, how immigration knows visitors are working illegally in the United States. They don't have a, a mind reading or special tool for this, but they do raids. Some people complain. Somebody, maybe just a concerned citizen who complains, or it could be another employee, disgruntled employee, somebody who reports. So there are many different ways. Or sometimes they do raids. They come to the big restaurants, factories, and so on to check on the status of the employees. I had one client who was an F1 student who was working at the gas station. I think what happened was, I don't know exactly what happened, but somehow there was some issue. I think it was alcohol sales and so on. Anyway, they ended up finding out that he was a student here on a student visa, and the ICE detained him and so on. But thankfully, everything ended up well because he was married with a US citizen down the road and things worked out. So anyways, things can happen. There are many ways it can be found working illegally. Now, again, I want to make sure that everybody understands working illegally in the United States is not a crime by itself, is not an immigration violation of itself. I'm not saying that it doesn't end up in the violation of immigration status, but working without authorization is a violation of your status, which breaks your status, which makes you either deportable or ineligible for the immigration benefit. All right. And I see these questions: how to work in the United States undocumented. I mean, I'm not gonna, comment on how to work in the United States undocumented. The bottom line is, if you do, you can be caught, but your employer can suffer. If you work without authorization, your employer, if they are found to do it frequently, what they call pattern and practice of hiring undocumented aliens, individuals without authorization. Basically, they didn't present the document showing that they're authorized. If that's frequent and they do it knowingly, then they can be even criminally charged. But there are civil fines for the employers, not the employees. How long does it take for the supervisor to review an active decision of interview officer made? Okay, so I assume this refers to asylum interview. It's different for the supervisors reviewing asylum interview cases and in the marriage-based case or other type of adjustment of status or citizenship-based. So in the asylum interview cases, I think they still have a shortage of officers and supervisory officers to review the decision of the officer. The officer makes a decision, makes recommendations and notes, and then the supervisor blesses it, and that's how the decision is made. So in the context of asylum, we've seen asylum cases pending for years, where each time after the interview, we all know about the years of asylum interview waiting, but after the interview, we've seen them cases pending for years. And then each time we make an inquiry, the asylum officer responds saying that it's pending the review of the officer. So it can take months, it can take years. Nobody knows. All you can do is make inquiries. In the context of marriage-based case, typically that's about 2-3 days or less. A lot of times you have, not just marriage-based, but also employment-based. So in the context of adjustment of status and naturalization, most of those cases, usually the same day or within 2-3 days, because compared to asylum, it's more straightforward. All right. Excellent chat session. Thank you for sharing your experience. Thank you very much for listening and participating. How to apply for U.S. immigration from Pakistan? Well, there is no special method to apply for citizens of Pakistan, except that Pakistan is one of the E2 investment treaty countries. So E2 investment based visa is a very lucrative, very good type of visa, which is beneficial and helpful because it acts almost like permanent residency in a way that you can always extend it indefinitely. You can remain in the US, you can travel in and out, you may have to renew the visa stamp and passport, but that's kind of straightforward process. Your children are residents for the purposes of for public schools. They can go to public schools. Your spouse can work without authorization. They recently actually changed the policy. You don't even need to apply for a separate EAD if you're a spouse of an E2 visa holder. So E2 is an investment visa for small businesses. As we all know, for anybody from anywhere in the world, there is a investment-based permanent residency, EB5, which requires substantial amount of investment, which is 1 million or 500,000 in target areas. Under the Trump administration, they changed it to 1.8 million and 900,000, and then it was reversed back. But that's substantial. That's for large investment. But what if you have $80,000 or $100,000 that you want to start the business with, some kind of small business? And that's what E2 investment visa is for. And it's based on the international treaty between the two countries. The United States has that treaty with Pakistan. It has a treaty with some of the countries, but does not have with some others. So, for example, there is an E2 treaty has been in place with Ukraine, Azerbaijan, Pakistan, Kazakhstan, but there is not with Uzbekistan or Russia or some other countries. I don't remember the list. There is a list. It's easy to find, but Pakistan is one of those countries in the E2, so it may be something you may want to consider. Look at our website, islawfirm.com. It's posted in the comments, and you can read about the E2 visa in the business immigration section. And then you can schedule a consultation. All right. Okay. How to move to USA from Europe. Same thing. There is no special separate category with Europe. Now, you can not move. You can visit the United States with a visa waiver program for most of the Europe. Your passport, EU passport, qualifies you to enter the US up to 90 days without having to apply for a visa. But you have to register with that ESTA program. I think it's online registration. But in terms of moving to the US, same thing. E2 visas work for most of the countries in Europe, and it's a very good way to start. Even if you are planning to get an L1 visa, which is intra-company transfer, you have a business abroad and you want to start yours open a branch office or affiliate or new business in the US, and you want to apply for L1, or you want to apply for a green card based on that basis, which is L1A and then permanent residency, or if you want to invest substantial amount of money in your business and apply for EB5, E2 is always a very good ramp, the first step towards that. So E2 allows you to come into the US fairly quickly, within a matter of months from starting a business, from actually deciding to apply for E2. Within a matter of months, you can actually bring the family, come here. You don't have to show close ties to your home country anymore, different from, B1, B2 visitor visa or a student visa, different from those. For E2, you don't have to demonstrate that you're going to go back to your home country, that you have close ties. In fact, you can sell everything out there and you can come to the US to manage your business. So it's fairly quick process, easier, less costly, and a more affordable small business. And you can start small, get the E2, come to the US, and then develop it and expand it to grow it for EB5 or, for L1. All right. So consider that. My Ukrainian friend has a humanitarian parole and wants to apply for a temporary protection status. However, she arrived after April 11, 2022 date. She arrived April 25. So unfortunately, the TPS only is valid for those who entered before April 11, or April 11 being the latest. And there is no update as to that, but it's possible they may renew and redesignate Ukraine, which they frequently do with some other countries, like Yemen, for example, recently, I believe they did, which will capture all of those who entered after April 11, those who were paroled into the US. But, in light of this question, I'm going to talk about renewing parole for all Ukrainians. So Anybody who entered before April 11, they could have and should have applied for TPS. You can still do temporary protected status. Is a status which allows you to remain in the U.S., work in the U.S. You can even get travel authorization to leave the U.S. and return. And it's additional layer of protection aside from your current status. So even if you have a visitor visas, or if you're on student status in the U.S., even if you have E2 investor status from Ukraine, your H-1B work visa, work status, then you can still apply for TPS. That's just additional layer of protection that you're not going to be deported, you're allowed to stay here. And again, it also gives you benefit of employment authorization. For example, for students, F1, whoever is here, you can apply for employment authorization as long as you have TPS. But those who entered the United States after April 11, they're kind of stuck. What should we do? They were paroled, but then their parole is not 2-year parole, not TPS 1 point, or other than those who entered to U4 United Ukraine. So there is no process currently, no official process to renew the parole. To get the parole, again, you'll have to depart and return. So most of those clients, as long as they have reasonable fear, as long as they have fear of returning to Ukraine, then we recommend to file for asylum. And we're glad to help. And we've got asylum approved in the immigration court, but most of those asylum applications that we filed so far since the beginning of the Russian aggression in Ukraine are still pending. And the decisions, and no interviews have been scheduled, and I don't think USCIS is going to rush into scheduling those interviews. So they are pending, and no decision has been made for us to report on, nor for my colleagues through American Immigration Lawyers Association. Nobody has reported that, oh, yes, we were able to get back-to-back approvals and so on, or any approvals so far. But in immigration court, I had cases where the judge approved based on the humanitarian reasons, approved asylum for those cases who were already here on pending asylum, but humanitarian asylum based on that pending. But there is a separate video. I'm going to make also another video about this on humanitarian asylum for Ukrainians, and to be honest with, for anybody from any other country. All right, what other option does she have to stay in the country? As I said, if she entered and paroled, it was 1-year parole, it's about to expire. My recommendation is to file for asylum as long as there is fear of returning. There is a danger, which is, there is a danger in Ukraine, there is war going on. But as long as she has also subjective fear, then she can apply for asylum. Okay, if you have already applied for asylum in the US, okay. So what is the processing time in Houston, Texas? Affirmative asylum filed in October, yet to get a receipt. Yes, so asylum applications, the receipts that for asylum applications have been significantly delayed. It has been taking 5 months, 6 months. Now we have some cases which are over 7 months, and the receipts are not haven't arrived yet. So the asylum applications that were filed by mail, but the USCIS disclosed it. They have announced that those receipts are delayed. Don't freak out. Don't file again. That will actually cause more backlog, and I think part of the backlog is caused because of that. Once those receipts were delayed, a lot of applicants freaked out and they filed again. To be honest, before USCIS announced, we actually did it in a couple of the cases, and then the receipts arrived for the previous filings. So don't do it. Don't freak out. Just wait. But what they did now is to prevent this from happening is they opened online filing. And not everybody is utilizing this, but every single asylum application now must be filed. No, must be. You can still file it by mail, but that's dumb because if you file it, then you're going to have to wait for 6-7 months before you get the receipt. By that time, you would be EAD eligible, but without the receipt, how do you apply for it? You can still apply for it, but you're not going to have the receipt. But you're not going to have your driver's license. You don't have proof that you're lawfully present, which the receipt shows. So it's not wise to file it by mail today. So all of the asylum applications today should be filed online. It's an easy process. You create an online account, and it started recently, about a month ago or so. So, but yeah, interview in Houston, Texas, you're talking about years of wait time, probably. All right. Hello, sir. I want asylum and would like to file for my wife and child. How long will the process take? Unfortunately, it's not a quick process. It will take about 12 to 18 months normally, and sometimes more. But if there is a basis, strong humanitarian reason, you can request to expedite on both levels. By both levels, what I mean is when you file the Form I-730 with the USCIS, you can request to expedite with the USCIS, but that doesn't mean that the State Department will also expedite. The consulate doesn't mean that the consulate will also expedite it. So you should use the same basis to request an expediting of the consular interview. But yeah, so it's delayed, and if you expedite it, it may be months. But it has to be strong humanitarian reasons, such as either danger there, that they're being harassed or subject to persecution, or that the conditions there are so dire that for example, if it's one of the countries that are going through the war, revolution, or significant economic distress. Okay. Applied for TPS EAD recently. I do have also pending asylum almost 5 months ago. If EAD from TPS takes longer, can I apply for EAD based on pending asylum? Yes, you can apply. You can apply. Those EADs don't conflict with each other. Those are two different categories of EADs, and you can apply. But if you have an EAD and it's valid, and you have a pending asylum case. Now, this person who asked this question didn't have it, but I'm just saying in the future, and you have a TPS, don't file for EAD just to have two EADs. That's not helpful. Unless you're about to lose your asylum case, or you're about to withdraw your asylum case. Can the USCIS ombudsman help speed up my immigration case? Well, what does speed up mean? Is it stuck beyond normal processing time, which is currently taking place, or do you want to be before everybody else? Do you want them to move you ahead of others in the line? So the ombudsman cannot move you ahead of others. You have to file for expedite request with the USCIS. For that, you have to have the receipt. You call the USCIS, do it early in the morning to have least amount of hold time, and you request the expedite over the phone, providing the information, the receipt. There are 3 outcomes after that call. USCIS can approve the expedite based on the information you gave them. That rarely happens. Second, they can deny your request based on the information you gave them, if they realize that what the information you gave them is not sufficient, even if you are able to prove what you told them. Or third, which is more likely, they usually send an email asking to provide evidence in support of your claim for expedite request. So if you want your case to be heard first, you have to have strong reasons. A lot of times when clients tell me about this, ask me, oh, what can I do? Can I ask to expedite my case? The analogy I give them, I tell them, look, imagine you're at the airport, right? We've all been there, and that's, one of the painful things. That's why I bring this analogy. So you're at the airport, you're at the check-in, or going through the security, and in front of you there are 300,000 people, and you are telling everyone to move aside. Everybody should move aside, and you're gonna go first. That's what expedite request means. When you say, oh, how can I get my spouse in the US faster, ask the USCIS to process my case faster, although it sounds innocent, but what you're saying is, how can I tell everybody to move aside? How can I tell the United States Citizenship and Immigration Service to push everybody aside and let me go first? And the answer is, it's possible if you have an emergency, and you better be able to prove it, because if you lie about it, not only they're not going to let you go first, but they may actually punish you by pushing you back, if you lied to them. Or at least you're going to be laughed at if you say something ridiculous, for moving everybody aside, so that you go first. So that's what expedite request means. So, don't place an expedite request providing false information. That's number one. Because sometimes people read the basis for expedite, for example, or urgent humanitarian reasons. well, let me come up, and then they come up with some, thing that is not true. And that hurts your credibility, especially if you're an asylum applicant and so on. Or it could be actually found as material misrepresentation. You're misrepresenting information to the federal government. So don't do it just to try to push your case forward. It can actually backfire and hurt you and hurt your underlying case. But in terms of ombudsman, no, the ombudsman's help is only if your case is stuck beyond normal processing time. And normal processing time is determined by what the USCIS publishes. So they look at their workload. So, for example, normal processing time before Trump administration for naturalization cases was about 3 to 5 months. And then it got to 8 months and so on. But now I believe in some service centers, a few offices, it's like almost 24 months and so on. So normal processing time changes. So check on that. If your case is beyond normal processing time, then the USCIS ombudsman may be a good source to try to help you. Just make inquiries. It's a very straightforward process. Okay, please, any news about the 7-year rule? I don't know what 7-year rule refers to. Please be specific on what you mean. Can I file for work permit 150 days after filing for asylum, even if I don't have the receipt? That's a good question. We haven't filed it yet, I'll be honest with you, but I don't see why not, with an explanation, because it's the same agency, it's the USCIS, so they have access to verify. Now, there is a 1-800 number that you can call and check on if you have a number. If you don't have a number, then the USCIS receipt is the one who is going to give you a number. Or if you don't have the receipt, you can also send an email to the local asylum office, try to get that information. But the bottom line is, I think you can. I don't see why not. You shouldn't be able to provide the information that you filed, and the receipt is somewhere out there. It's just you haven't received it yet. All right, we're at 11:54, so 6 more minutes. Hi, sir. My sister's son is 17. He is coming to the U.S. Okay, let me ask you. I'm sorry. I have some workers here. Today I'm working from home, and they are installing some of the system upstairs, and that's what's going on. So I get texts that I need to go back to them. But we have 5 more minutes. Let me just let them know. I apologize. All right. Okay. So going back to this question, what was it? Can I file for work permit? No. I want asylum. Would like to. Okay, we spoke about that. Can I file for work permit? Okay, we do. I saw my sister's son is 17. He's coming back to the US in March. Is he qualified for DACA? He's coming back on March. No, DACA, there is a certain period of time. You need to consult with a lawyer. That's very specific question about specific case. But generally, I would say no, because the time during which one should have entered the US has already passed under DACA. Do TPS and TPS-based EAD approvals take long? Yes, they do take long. What's the average time to get approvals? Well, I'd say 2 months, roughly, around that time. Not as long as the marriage-based EADs, which currently take about adjustment status-based, I-485, take about 6 months or so. Can a disability like vision problem give advantage in asylum process? I mean, it can give you sympathy, but generally, disability doesn't give you any legal basis for asylum or doesn't make your case stronger unless you are claiming asylum from a country where people with that type of disability are being harassed or mistreated. And there are some countries where some disabilities are viewed as inhuman-like, or they're treated badly, or they're treated like this person shouldn't have even existed, or why is this, why didn't they get rid of this person? So unfortunately, there are some societies, some countries where this takes place. So in that type of case, disability could be basis for asylum under a particular social group category. Okay, I think all of the questions are answered so far. If you have further questions, please feel free to post. You have our information, the email, the website in the comments. You can call our phone number. You can text our number, and we will receive the text. You can email us. Now, when you email us, if you call us or text us, what will happen is one of our associates will give you information as to how to schedule a consultation. So, when you send those questions, you're not going to get answers to those questions. Nobody's going to be sitting and spending time to necessarily answer all those questions, because otherwise then we would be doing this all day long and the firm wouldn't exist. So part of what we do as immigration lawyers is actually a big chunk of the immigration lawyers' work is providing advice, consultations. And if you need advice, you have questions to ask, and you want consultations, when you contact us, you will receive a response with a link where you can go and click, and you will have calendar, and you can choose the date and time that you want, the available date and time that you want your consultation. The consultations are done either online through Zoom, WhatsApp, Skype, or by phone. If you're in the United States, you can decide that you want to talk on the phone. So you can indicate that there. If it's through Zoom, for example, you will get a link to Zoom. If it's through WhatsApp, you need to indicate your number, the phone number for the attorney to contact you, for me to contact you through WhatsApp. So you will receive that information, and the consultation fees are $250. And these fees are deducted from future fees if you retain our services. So for example, if you call us and we spend time to give you information, I consult you on your asylum case chances, on your ability to follow what needs to be done, and then down the road you hire our firm to handle the case, then those fees will be deducted from the future fees of your case. So that's as a credit, then the consultation becomes free. So please also hit like and subscribe to our channel so you're informed about next sessions. I believe we're going to have next session also next week. So next Thursday on the 19th, and I will be in the office, and we will have a next session answering questions. We'll post the announcement and the topic of that session also here. So please join us next week on the 19th. And again, please subscribe, hit like, and comment. We're going to try to answer as many questions as possible in these comments even after this stream. Thank you very much, and have a nice rest of the week.